Hello friends, welcome to our channel Legal Nexus. In this video, we are going to discuss about various relations arise by vicarious liability. The major relation in which vicarious liability of a person arises: master and servant, partners in partnership firm, and principal and agent. Master and servant. In a master and servant relation, the master employs the service of a servant and he works on the command of master, and thus a special relation exists between the two, and in case of a tort committed by the servant, his master also liable. There are many cases in which the servant doesn't act for his master, and thus in law it is deemed that the master was doing that act himself. Therefore, if the servant commit an unlawful act, the master will also be liable for the same. Liability of master is based on the following two maxims: qui facit per alium per se, respondent superior. Essentials of vicarious liability in master and servant relation. These essential conditions have to be followed for the vicarious liability of master to arise. The servant has to commit an act which amount to a tort. Such tortious act is committed by the servant during the course of his employment under the master. Reason for liability of master. There are several reasons behind holding the master liable for the acts of his servant, which are: an act which is committed by the servant is considered to be done by the master through him, and therefore in the law of tort, it is assumed that if any wrong is done by the servant, it has to be committed by the master indirectly, and so the master is held liable for these wrongs, and the master is in a better financial position as compared to his servant, and thus in case of any loss caused by the tortious act of servant, the master is better suited to pay of the damages to the victim of the act. Also, since the master is made liable, he makes sure that all reasonable care and precautions are carried so that he can avoid such liability. When a servant does any act, the benefit from such an act is enjoyed by the master, and thus for the liability arising out of the servant's act, the master should also shoulder that liability. Various ways in which liability of master arises. Only the following three conditions makes a master liable for the tort committed by his servant. 1. Wrong done as a natural consequences of an act by servant. For the master, due care. If employee does an act which is done in pursuance of instruction of the master, then the master will be held liable for any wrong which arises out of such act, even if all due care is taken by the employee in discharging his work. Wrong due to negligence of worker. A master is also liable for an act of servant which he does negligently or fails to take due care and carry out. In Pushpal Purushottam Udeshi and Organization versus Ranjit Ginning and Pressing Company. In this case, deceased was traveling in a car driven by the manager of respondent company and met with an accident, as a result of which he died. The dependents of the deceased file a claim and tribunal allow damages, but on appeal the High Court it was set aside on the ground that the accident does not make the respondent company liable. But the Supreme Court in its judgment overruled the judgment of High Court and held that from the fact of the case it was clear that the accident occurred due to the negligence of the manager who was driving the vehicle in course of his employment, and therefore the respondent company was liable for his negligent act. Wrong by excess or mistaken execution of a lawful authority. For making the master liable in such a case, it has to be shown that the servant had intent to do an act on behalf of his master, which he was authorized to do. The act would have been lawful if it was done in those circumstances in which the servant mistakenly believed were true, or if the act would have been lawful if done properly. Let's talk about the difference between servant and independent contractor. A servant is an agent who is subject to the control and supervision of his employer regarding the manner in which the work is to be done. An independent contractor is not subject to any such control. However, he undertakes to do certain works and regarding the manner in which the work is to be done, he is his own master and exercises his own discretion. He is not under the order or control of the person for whom he does the work, and in the aspect he is different from the servant who acts in strict obedience of the direction of his master. In V. Govindarajulu versus MLA Govindarajamudaliar, a motor lorry was entrusted by its owner for the repair while an employee of repair shop droid there was an accident. The court held that the owner of the lorry was not liable vicariously because the owner of the workshop was an independent contractor and not the servant of the lorry owner. Liability of employer for the torts of independent contractor. Generally, a master is not liable for the torts of an independent contractor, but under the following circumstance, master is liable for the torts of an independent contractor. An employer is liable for the act of independent contractor in case of strict liability. If an employer or master instigate independent contractor to commit a tort, he is liable for the tort of independent contractor. An employer whom there is a legal or statutory duty is responsible for the torts of independent contractor. Terry versus Ashton. Ashton fixed a lamp outside his house. Due to negligence in fixing it, a passerby was injured. The court held that Ashton was liable as it was his duty to see that it was fixed properly. Liability of independent contractor. An independent contractor is liable for all acts of his employees or workmen employed under him under the principle of vicarious liability for all the injuries sustained by the employees in discharge of the contract work of third party. The independent contractor in capacity of employer alone is liable and not the contracting third party. For any loss or damages caused by the acts or negligence of the employees of the independent contractor to third party, he is liable to compensate the third party for such losses or damages.